turn it over to today's presenters.
Hello, everyone. This is Gail Pendleton, Executive Director of ASISTA Immigration Assistance. And with me today for this new webinar that we are doing for you is Cecelia Friedman Levin, who is our Senior Policy Counsel. Next slide.
Hi, everyone.
Am I supposed to do the slides? Okay, I'll do the slides. Oops, wait, let's back up a second. Okay, so the goals of this training are to help you identify problems that arise with the basic elements in VAWA self-petitioning and U visa cases, to discuss with you questions that you are encountering as you work on these cases, and to strategize with you about the best practices in framing your VAWA self-petition and U visa cases. So we're going to start with a hypothetical because we believe very strongly that the best way to learn is for you to think about things and share them. And we often find that we learn from you in the process of doing this. So we're starting with a very basic facts that you know. Alia is an undocumented survivor who's living in your geographic area. She tells you that she is married to Ivan, who is physically abusive. So, based on this, what do you think Alia might be eligible for, and what else will you need to know to figure that out? And please use the chat box to answer the questions. Let's start with the VAWA self-petitioning. What else will you need to know if Alia is eligible to VAWA self-petition? And I can see multiple attendees are typing. Right, so whether Ivan is a citizen or lawful permanent resident, very good. What else? Right, are they married? Are they currently married? Are they legally married? If not, when were they divorced? Okay, anything else you want to know? Okay, I'm just waiting for Maria to type. The evidence of abuse. Yes, very good. Good job, ladies. And I think we've got some guys too. Encourage you all to participate. So now let's move on to what would you need to know to decide if she's eligible for a U visa? Just the basics. Have there been any criminal charges filed? Right. Anything else that you need to know? Has she been helpful? Cooperation. What was her helpfulness? What was her cooperation? Could she be helpful? She hasn't yet. Okay. Something's happening where I'm getting the chat filling up my whole screen. I don't know what I'm doing wrong here. Oh, good.
Yeah, sorry. If anyone of the presenters maximizes a box, it will maximize for everyone.
Okay, thank you. I'm just not seeing the chat responses, and so I'm not able to follow along, but I'll work out with the chat.
Oh, sorry. So Cecelia, I'll keep reading them until while you.
Yeah, thanks. That'd be great until I figure it out. Thanks.
Okay, and so then Norma also suggested that we want to know Ivan's status if she's cooperated with the authorities, and which authorities did she cooperate? When did she do it? How did she do it? Good job, folks. You've done a good job of identifying some of the basic things you need to know to decide what she might be eligible to apply for. So let's move on to do VAWA self-petitioning. Just as a preface, as many of those of you who have been doing U visas are probably very aware that there is a huge backlog in those cases. They're not even opening the files for 2 years after they file them. So that's one of the reasons we are encouraging you to go back through your U visa filings and identify if any of those folks could apply to VAWA self-petitioning, because there are still far fewer of those being filed, and we think that if your clients are eligible for that, they might get status a little faster. All right, so now we're going to add to the hypothetical, which comports with what you all were saying. Alia says that her husband's a lawful permanent resident, but she doesn't know how she can prove his status. What could you use to prove that her abuser is a lawful permanent resident? And we're going to set up a poll so that you can answer through the poll, I believe. Is that right? Yeah. So do you need to, looks like you all know how to do this. Okay. Yeah, so the choices are statements from her, how she knows he's a lawful permanent resident, supporting statements from other, ask the civil court to require document production by him or to make findings if he won't produce them, ask U.S. Citizenship and Immigration Services to electronically verify his status, basically check their databases, all of the above, and anything else. Okay, looks like all of you are going to do all of the above. And if any of you have any suggestions for other things that you have been doing that you would like to share with us, please put those in the chat box. Let me ask you also, how many of you have actually asked a civil court judge to do either require someone to produce the documents or to make findings that would be helpful? Let us know in the chat box. And while you're doing that, one of the things I'd like to point out here is that because of the abuser's control of documents, this is where Congress created a special rule for the evidence called the Any Credible Evidence Standard. And that's why the things like the statements from her and the statements from others can be used in this context, because he often has all the normal documents you would use, for instance, in a regular family-based petition. Okay, so it doesn't look like anyone's saying they've used the civil courts, and I would highly encourage, oh, wait a minute, in divorce proceedings, Guadalupe says, the family law attorneys have requested the abuser to produce a copy of his green card. Very good. And Sophia says she's requested in discovery. That would often be in divorce proceedings or custody, and the court compelled the party to produce it. That's excellent suggestions. And just so for those of you who work with family law attorneys or who may be going with clients to civil court, the argument, and we do training for judges, so I know this flies with the judges. The argument with the judge is, Your Honor, this control of the documents is part of his or her pattern of power and control, and therefore you can do something about it. You can, quote unquote, sanction it as part of your sanctions for power and control. And what his power and control is doing is preventing her from being able to apply for the immigration status that Congress created for her. So in addition to doing that in discovery or in the context of divorce and custody, consider asking for that as part of that other box on most of your protection order requests, because that's exactly what protection orders are supposed to do. They're supposed to hold the abuser accountable and get her what she needs. And for many immigrant survivors, that means getting the information about his status and about some of the other requirements for either a VAWA self-petition or a U visa. So if you have questions about that, please feel free to contact us afterwards. That's one of the things we're here for, is to follow up on our training, both for individual cases and for ideas on how you can train your systems. And we have, for instance, slides for training judges, because we do training for civil court judges on this. Okay, good job, folks. Let's move on. Other VAWA eligibility issues. So I want to ask you, for those of you who are doing VAWA self-petitions, are you seeing issues about showing that it's a legal marriage or the exceptions to legal marriage? And maybe those of you who've done them, if you want to share, what are some of the exceptions to having to be legally married at the time you file an application? Because if you're familiar with our normal immigration family system for filing, you would have to show you were married at the time you filed. Okay. So for instance, some of you may be new to this, and this, and so we're not actually doing kind of a basic training on this, but you can find some of our taped webinars, recorded webinars through TA to TA that go into more of the basics here. But typically, the problem would be if your client was divorced from the abuser, because that might be an obvious thing that a survivor would want to do. So we're getting a question on whether others have lost their audio. Can you gals at TA to TA figure out what's going on with that? Okay. Okay. So, and then, all right, this is a good one. Someone mentions that we've had to go back over reference materials on Islamic marriage contracts to help show that it's a real marriage, a legal marriage. Yes, that's a very good point. So let's start from the basics. Let's say your client is still married to someone, but it wasn't in the United States, or it wasn't registered, in a civil court. One thing to know is that under immigration law, the definition of a legal marriage is a marriage that was legal in the jurisdiction in which it took place. So, for instance, if they were married in another country, you would have to show that they followed the rules on legal marriages for that country. Also, inside the United States, some states recognize common law marriage, most notably, I think, Texas, for instance. You can.
And DC, yep.
And DC? Okay. So you can file a self-petition if you show that you meet that state's definition of common law marriage, even though they've never been registered in a civil court. So one practice. Sorry, go ahead, Cecelia.
Sorry. No, I think the other thing I just wanted to flag for folks if they weren't familiar is also sometimes there's difficulty getting those documents, particularly if a marriage occurred abroad, and that the State Department has some excellent guides in terms of generally which documents are available, which are hard to get. And so if you're running into issues in terms of proving that documentation, then that's a really good resource. And I can kind of put that in the chat box as well.
That would be great. And then another issue that arose, so the original law was passed in 1994, and there have been 4 or 5 changes to it that reflected the experience we had once the law started being implemented. So later on, Congress created an exception for those who were divorced from their abusers. If the divorce was in 2 years of you filing the self-petition, someone can still qualify for a VAWA self-petition, which would not be true if the abuser was filing in the regular family-based system. Similarly, we discovered that many abusers were bigamists, and so there's an exception if you can show that your client married the abuser in good faith, as they say, which is a lawyerly word, good faith, and she didn't commit the bigamy, but he did. Because normally, if someone marries a second person without divorcing the first spouse before marrying the second one, the second marriage is not a legal marriage and wouldn't qualify for immigration purposes. But it does for VAWA if you meet the requirements for it. Right, so the divorce is the 2 years, as Norma is mentioning. It has to be within 2 years. Okay. And you will be getting well, I think they're getting the slides right as part of the materials, right, ladies, at TA to TA?
Yes, everyone was sent the materials yesterday in the reminder email. But you can also download them below the PowerPoint right now.
And you can always get them from me and Cecelia afterwards. We'll be, we like to share this kind of material as much as possible. And at the end, we'll share with you our website where we post a lot of free information, including all the recordings of our prior webinars. So Cecelia has now put in the link for finding how immigration looks at what documentation you must show if you were married in another country. So before
and the availability of those documents, because sometimes they're just not going to be available, and that'll give you an idea of, one, how to get them, and two, whether or not they're even available in country.
So now David's asking whether civil unions are acceptable. And so I assume you're asking about gay and lesbian civil unions. Again, the general rule applies. So in those states where it's recognized as a legal marriage, like my state of Massachusetts, then yes, that's being recognized. In those states where it's not, I don't think, Cecelia, it's being recognized as a legal marriage, although it's an interesting idea based on the recent Supreme Court decision overturning DOMA, the Defense of Marriage Act. But
Right,
David,
so the same-sex marriage is legal in all 50 states.
what was that? Can you repeat that?
Yeah, the same-sex marriage is legal in all 50 states.
For immigration purposes?
That for federal purposes. Yep, everything.
Okay. Yes, so even that's an interesting exception to the general rule that I told you about. You will have to, I think, probably, I don't know actually how you prove that. I mean, I guess you could assert it based on the Supreme Court decision. If they come back with a request for evidence, then just, we can help you figure out how to prove it. We actually haven't seen that issue coming up for states that haven't actually approved, don't have legal marriages. So let us know if you're running into that. Any other marriage questions? The legal marriage questions. Okay, so let's move on to proving battery or extreme cruelty. What non-physical kinds of domestic violence are you showing in your VAWA self-petitions, and how are you documenting it? And this, again, is an area where there is room for a lot of creativity, because there are, unfortunately, many forms of domestic violence. Okay, so we have the power and control wheel, right? And there's a special immigrant power and control wheel that includes, for instance, things like manipulating the control of the immigration system. It expands on things like isolation to include isolation due to inability to speak the language and communicate with systems, not knowing about systems and being given misinformation about the systems and the rights in the system. So you go over that power and control with your client, and you get a declaration on their answers. And one practice pointer I would suggest is if your application is based solely on non-physical kinds of abuse, which means you're unlikely to have what we call quote-unquote systems evidence, like a protection order that talks about that, or a hospital records, then you may want to get declarations from others who have been told about it by your client, or from a counselor who's been working with your client and can talk about the facts that she's talking about and explain why what she's talking about is a form of abuse, like isolation or humiliation or degradation or economic control, all those things that you're familiar with. Don't assume these days that the adjudicators are going to understand that those are forms of domestic violence. So you need to...
Right, and that's something that David had just pointed out, the kind of letters of support describing the emotional abuse. And if I could just add on to a little bit to what you said, Gail, about some practice pointers for declarations. And I think this is, it's true across the board, and I think particularly in extreme cruelty cases where it's sometimes, a re-traumatizing act to put these declarations together. But the details about, for example, working with clients and say that there was insults and name calling, and that, the abuser would call the survivor X, Y, and Z. And so it's putting that in a declaration is important, that which names were called, but also the next follow-up question is, how did those things make you feel? Because that is the nexus to the cruelty part, is the impact of the insults, of the social isolation, of the economic control. So oftentimes when I review, declarations, and I'm looking for those details about extreme cruelty, I'll see the facts, and I always write in the margins, how did that make your client feel? How did that make her feel? And it's a terrible thing, and so that's why I think we're going to talk about in a little bit, like the partnerships with advocates and partnerships with individuals who know how to ask those questions in the right way is important. But that's just, I think, part of the supporting detail about what's going to be, I think, important in putting your case together, in proving the battery or extreme cruelty.
Right.
And the other thing that Viviana mentioned is, that Maria mentioned is that systems evidence. I don't know, did you already go over that, Gail, about kind of, or I can just talk about it a bit?
I mean, from service agencies?
Yeah.
Okay. Yeah, I wouldn't actually call that systems evidence, but I think that's very important. Yeah. Go ahead.
Right. Accessing the system and accessing help. So, if a client went to the police and made a police report or went to the hospital for injuries, that kind of connections to what systems were accessed in order to kind of seek help is important proof in kind of proving up these the battery and extreme cruelty.
And one practice pointer on the declarations from the domestic violence services agencies, and I don't think we have the guidelines I put together in here, but they're on our website, is that just saying that she's come to see you 5 times is really not going to tell them anything. What it needs to be, like what Cecelia was saying, the person who writes it, and you'll see in the guidelines, it kind of says, this is what you say in the first paragraph, this is what you say in the second one, but the key...
I'll put them in the chat box, yeah.
Oh, okay, great. But the key to convincing immigration about that what you're saying is true is the facts. So talking about what your client told the counselor, why that was credible to the counselor based on her experience working with many survivors, and why that's a form of domestic violence. That's what's going to make that a persuasive, what we call corroborating declaration. And this is also another place where judges have been very willing to make findings about non-physical abuse in protection orders. Often it's based on the declarations your client filed to get the protection orders. And again, the way that I frame it for them is, this may not be something that you could even bring a criminal charge for, but it's definitely a form of domestic abuse that you see all the time. And they always say, yes, we see this all the time. And actually, they're glad that there's a way that they can write it down and in a way that's helpful for your client. Okay, so are we ready to move on? David's writing something and Cecilia's writing something. So does anyone have any questions about proving battery extreme cruelty before we move on? Okay, and again, one of the things we're here for you, is if you get pushback from immigration, let us know, because we have spent years and years over and over educating them about the context of domestic violence, and often when they add new people making the decisions, they're not as well educated, and we have to do it again. So one, practice pointers don't assume they're right, but they may have a point on some things like your declarations need to have more factual detail, and we'll help you with that, as well as with the arguments to push back on what they're asking for.
Right, and the only other thing that I will say is that there is an opportunity, as Gail mentioned, for creativity. So if, something comes in my name at the address, and then another document comes into my spouse's name at the same address, then both of those documents are useful to show the shared residence, right? And so I think that you kind of really have an opportunity to kind of be creative when you're trying to meet the requirements of the application.
Right. So she's talking about these obstacles we see, which we'll get to in a minute, because that's what we're seeing, the biggest problems. But we did want to talk about the partnership model. So who do you all partner with? And assuming you are partnering, how do you distribute the roles in working with the clients, both to get the story and to help get documentation and other services that they need? Like, just so you know, we can't tell like what kind of grantee you are, whether you're a lab grantee or a rural grantee or something else. So we can't tell, for instance, if you're all attorneys or some of you are domestic violence advocates. So please share any practice pointers you have on the partnership models that you are using. Okay, it doesn't look like anyone's doing it. So I'll tell you the partnership model that we've been promoting ever since the law was passed. And it reflects the partnership model that we've used at the national level for many years, which is that when you're working with survivors of domestic and sexual assault, the survivor, as you know, needs many different things at the same time. And so rather than kind of silo the different services, we highly encourage the lawyers to work with domestic violence or sexual assault counselors, depending on, the kind of crime they've suffered, and vice versa. And that for the lawyers in the audience, there's a lot that the counselors can actually do to help both get the story from your client, to help them put the story together in a coherent and useful way, and to help find other evidence. And to be honest with you, unless you've been trained in domestic violence service provision, they're probably going to be better at some of that than some of those of you who are lawyers. And we recommend that the lawyers really focus on all the other eligibility issues that perhaps someone who isn't trained in the law might not be as equipped to do. Now, one of the issues that arises typically from this partnership model is how you avoid what us lawyers call privilege piercing. And since it doesn't look like you guys are doing it right now, even when you start doing it, as we encourage you to do it and you develop those partnerships, let us know and we can help you figure out the models that will work to ensure the confidentiality and that the abusers and others can't get the documents from you or from the lawyers or from your client. Okay, well, some people are typing, so we can come back to this, but why don't we, you have releases that survivors sign. Okay, we can talk to you more about what that means. As others are typing, let's come to the obstacles that we see. And both. Okay, so one of you is a legal services off. Oh, and you partner with a DV shelter and other services organizations. Good, right. Yeah, so the issue I'm suggesting actually isn't so much whether you have your client's consent, is how you set it up so that if someone tries to subpoena the documents, you don't have to give it up. Which the bottom line is most of the documents need to be in the lawyer's possession, is the bottom line. So if you have questions about that, we're happy to talk to you about how you could organize your system so that if someone tries to come after your client's files, it will be hard for them to do that because they're protected by the special privilege the lawyer has with a client. Okay, so Cecelia, why don't you, I know we've all worked on these requests for evidence and denials for VAWA self-petitions based on good faith marriage, and often it's similar to the residence requirement. Do you want to explain what you've been seeing and how we've been trying to help people with that?
In terms of good faith marriage issues? Sure.
Yeah,
so I think, so sometimes I think that they're, well, first of all, I'm going to back up a little bit because into the credible evidence standard and why it was put in place. It was put in place with the express recognition. And you can see this in the virtue memo on credible evidence, which is my favorite memo because everyone has a favorite memo. They just don't know it yet. So this is my favorite memo because go ahead.
It's in the attachment. That's the one in the attachments that says.
Yes. And it talks about the credible evidence standards, and because in the express recognition that people are maybe fleeing abusive relationships, and so what they consider to be kind of primary evidence of good faith marriage or primary evidence in general is not going to be readily available given the circumstances that survivors find themselves in. And so sometimes in the issues of good faith marriage, we see kind of sometimes adjudicators go away from this standard. Maybe they're coming from a different type of application, working for family petitions, but sometimes we see adjudicators or people kind of looking for primary evidence. And what do I mean by that? I mean evidence that is kind of formal documentation of entanglement of financial resources. And so what this virtual memo says is that an application cannot be denied for failure to submit one particular form of evidence. But sometimes we see RFEs that are coming back and saying, we want to see your tax returns, we want to see joint bank statements, we want to see mortgage statements or leases. And all of this is a higher standard of good faith marriage than what is intended, I think, when Congress created VAWA self-petitions as a form of relief. And so I think when we're seeing these higher standards, then we need to kind of push back and talk about what we have here in the slide, the best evidence and the credible evidence. So I think you can say, and how we frame this, is that the reason that I don't have a lease is that my abusive spouse didn't put me on it because he or she wanted to maintain the power and control of those things. I'm not on the bank account because my abusive spouse controlled all of the finances and the resources and told me I didn't have to worry about that. So we kind of encourage you to think about, if you don't have what they would consider to be kind of the best evidence, if you don't have access to a lease to prove joint residence or a particular sort of document, then say why you don't have it. And say, if they're looking for entanglement, financial entanglement, then say, we don't have that because my spouse was in charge of all the documents, and if that's true in your case. So think about what they're going to be looking for, and then think about responding to the fact of why you don't have those things, and how what you are submitting is credible evidence of good faith marriage. How those photos that you have together, how birthday cards back and forth, or emails that you have, or anything else that you're submitting, how that meets the credible evidence standards. So I think those are some of the obstacles we see, is kind of them looking for a higher standard than we think is what's required under any credible evidence standard that we see.
Right. And the good thing is, if you set it up like Cecelia says, where you basically head off at the pass, you address why you can't get what they normally would want to see, what we call the best evidence, and how, to the degree you could try to get it, how you tried to get it and then couldn't get it. Then turn to how the evidence you have supplied is credible. You've set it up so that it's really easy for us to help, push this through the system and raise it up to the folks at headquarters. Which to us, this is basically a training issue, that they don't understand the framework of the law and the context of domestic violence. Now, the one thing that they have pushed back on, which I think is useful for you to know, again, goes to how you do declarations, especially with the good faith marriage and the residence, but the good faith marriage in particular. It's very helpful if you start from the beginning of the relationship and give lots of details. So it's like I like to say the gory detail is what shows the idiosyncratic experience of your client. Put yourself in their shoes, and what you want to make sure you're not doing is making it sound like someone could just have gone to a website and figured out how to prove these cases. So, when I used to do asylum, I would literally say, so what happens when you wake up in the morning, right? And run through the whole day. So I would do the same thing with the marriage. When did you first meet? How did you meet? What did he say? What did you say? Then what did you do? That level of detail is what's going to convince them that it's a good faith marriage.
And if I could add on to that,
yeah, sure.
It's from those points, when you went for the first date or when you got engaged, again, I come back to those follow-up questions. How did that make you feel?
Right.
What were those first impressions? How were you feeling on those first dates? How were you feeling when you met the family? Again, I think those details about the impact, the emotional impact, not only of the abuse, but also of kind of the beginning parts of the relationship, I think are equally as important.
And one practice pointer I've suggested to people when I've looked through their declarations is go back and take out anything that sounds like an opinion and turn it into, and this would be for corroborating declarations too, turn it into the facts supporting that opinion. So I loved him is an opinion, right? Or how did you show that you loved him? How did he show that he loved you? How not he seemed like he loved me. He seemed like he was supportive. What were the facts that showed that? And that's really important for the corroborating declarations too. Because a lot of those we tend to see, it was clear that it was a real marriage and they loved each other. That's an opinion. What they want to see is the facts that support that opinion. Okay. So, adjustment and naturalization flags for VAWA. I'm not sure how many of you are actually doing a lot of VAWA self-petitions, but if you are doing VAWA self-petitions, you know that for them you need to show good moral character. Have any of you had any issues with showing good moral character? And what have you generally used to show good moral character? Letters of support, right. That's good. What the regulations require actually is a police clearance from every place they've lived for, I think it's 6 months or more in the past 3 years. And if you can't, this goes back to that best evidence point. If you can't get those, just show how you tried to get them, and then supply the letters of support, letters from the community, people that they're involved in. Oh, yeah, so FBI background checks, that's very helpful. Does anyone know how good moral, has anyone, let's back up a second. Has anyone had a VAWA self-petitioner who had an issue with having been convicted of a crime? Usually it would have been related to being a victim of domestic violence. And what have you seen with your survivors? What kinds of crimes are they convicted for that often arise out of being a survivor of domestic violence? I do this when I train judges, so they understand the impact of what's happening in their courts. So, yeah, Jessica's typing. So while Jessica's typing, let me ask you, and not just for immigrant survivors, driving without a license and traffic-related things, that is going to be especially related to immigrant survivors because they don't have the legal documents to show that they can get a driver's license. For survivors generally, we often see that they'll get convicted of domestic violence because the abuser knows how to manipulate the system. As Donna Lynn says, often petty theft, and often that's because of the economic control by the abuser. And the only way they can get what they need to support their kids, for instance, might be by shoplifting. So those are the typical examples I use when I train judges, because normally those would be huge problems for getting status. So for good moral character, Congress created an exception that said, even if this would normally bar a showing of good moral character, if you can show it's related to domestic violence and that there's a waiver in the law for down the line when you have to overcome the grounds of inadmissibility, then we may consider you to have shown good moral character. So here's someone who said, I had a victim charged with negligent child abuse. And that's often, again, because, they aren't taught, the system doesn't speak their language, and they're assuming that the victim is the person who's causing the problems, and they charge them with child abuse. But you submitted lots of documents from the court case showing she did all that was required for the children to be returned home. And hopefully that satisfied them that she showed good moral character. So the main reason there are two reasons I wanted to flag this for you. One is, again, don't assume that because your client has some crime issues that they can't qualify for VAWA self-petitioning. And that's what we're here for, to help you figure that out and how to overcome it if it is a problem, a barrier. And secondly, down the line, when your person, say they get approved, when they apply to get their own green card, these issues are going to come up again in what's called the grounds of inadmissibility that they have to overcome when they file to get their green card under VAWA. If you're doing U visas, you're already familiar with them because you have to overcome them when you actually file for the U visa. but we believe that there's a connection between how you've shown it for good moral character and what you're going to show later when you have to get the green card. And Congress did create many exceptions to the normal barriers of inadmissibility that would prevent others from getting their green cards, usually related to being a victim of domestic violence. So again, if you have concerns about that, it's really important to flag them now and not wait until later, so that we can figure out how you can, if you can overcome them, and if you can't, how to start documenting it so down the line she'll be able to get a green card. So unless you have questions about crimes that you're seeing and whether they can be overcome, we will move on to the next session. So derivatives, those are the family members that can tag along with the primary abuse victim who's filing. Those of you who've done VAWA self-petitioning, you've often, I'm sure, included children especially. Does anyone know what the definition of child is in immigration law? It's kind of unusual. It's probably, if you haven't done immigration cases, it's probably going to sound a little different. Someone suggested under 14. Actually, child under immigration law is unmarried and under 21. So you can be older, but if you get married, you are no longer a quote-unquote child for purposes of immigration law.
Right, and that site is at INA 101B. And it goes through situations kind of talking about stepchildren and out of wedlock. And so I think it's worth taking a look, because if you're dealing with someone and you're not sure whether or not they could potentially be included as a derivative, it's worth seeing how it's defined under the law, because sometimes it might be broader or more specific than you initially thought.
And that's a really good point about the stepchildren, because many of you will encounter survivors whose abusers originally filed an application for them as a spouse of a citizen or lawful permanent resident, but they many, many times will not have included applications for the child. But that child still might qualify, the child of the abused victim, who is not, a biological child of the abuser, may still qualify as a stepchild under the definition under immigration law. So that's really important to flag early because of the definition of it, and we can help you figure that out. The other piece that's important to consider is that if you have children derivatives who are about to turn 21, you may want to think about them applying on their own as VAWA self-petitioners, because there is this rule under immigration law that once you turn 21, you quote-unquote age out. And those of you who've done U visas are probably aware that we got a fix for that for U visas. But for VAWAs, it can make things very complicated. There are kind of semi-fixes for VAWAs, but it isn't as perfect or as pure a fix as we got for the U visas, where they become their own applicants. So often, and one way to frame this, and the Board of Immigration Appeals, which is the highest court in the immigration system, has an unpublished decision that says that witnessing abuse is a form of extreme cruelty. So if you can document that a child who's about to turn 21, a teenager, witnessed the abuse or was otherwise, a victim of the extreme cruelty part, if not the battering, it might make sense for them to file their own VAWA self-petition. And the other thing to know about VAWA self-petitions is there isn't a limit on the number of them like there is for U visas. So then another issue that came up, those of you familiar with domestic violence and sexual assault generally are probably aware that for many kids, they don't realize that what they experienced was domestic violence or sexual assault until they're older. And so Congress added a very special category, it's nowhere else in immigration law, that if someone who was a child at the time they suffered abuse, but then turned 21 before they were able to file a self-petition, they created a special category that you can still file if you're between the ages of 21 and 25. And it's got other requirements. I'm curious if any of you have done it, but it's definitely worth thinking about if you're dealing with older older, people in their 20s who are only now realizing that they were victims of abuse or who didn't know that they could file a VAWA self-petition. Then finally, as elder abuse became this, people became aware of elder abuse, Congress added a section that said if you're abused by a citizen son or daughter, which means sons or daughters is the immigration definition of children who've turned 21 or gotten married, basically. If you're abused by a citizen who is your child, essentially, you can also file a VAWA self-petition. We have not seen very many of those filings either. I'm not sure if it's because you're not seeing them or there just aren't that many cases so far. And then, remember we discussed age outs. There is another law called the Child Status Protection Act that allows complicated calculation that you can do based on when certain things were filed that allows you basically to backdate the age of a child who's attached. And we combine that with the section that Congress created for children of VAWA self-petitioners who age out. And that helps them retain the ability to continue with their application, but it's going to delay it significantly, which is why we suggest considering a separate application. Finally, and this is a little advanced, this section, but we want you to know about it. If you've got spouses of lawful permanent residents whose abusers never filed anything for them, so even after they file the self-petition and are able to work, they're still going to have to wait a while before they can file for their green card. There have been some successful attempts to bring in the children stuck abroad on what's called humanitarian parole, so that's something to consider. And just a footnote on that, every time you interview a survivor whose abuser is a citizen or lawful permanent resident, find out if that abuser ever filed anything for them, because if they did, you can probably transfer the date they filed that application to your client's application. And especially for those abused by lawful permanent residents, that can really hasten, make it much faster, the time that she'll have to wait before she can file for her green card. Okay. Okay, this is kind of extra credit, and this may be beyond what you all are experiencing, but we did want to flag it. So Alia was convicted of shoplifting in 2016 because her husband controlled all the resources in the house and she needed clothes for the baby. Is this going to be a problem for a VAWA self-petition? I guess we don't have a poll for this, but why don't you let us know? We kind of covered this, so hopefully this is more of a review. Yes, no, or maybe. What do you think?
Do you have a poll for this, Alicia?
What was that, Cecelia? Oh, great.
Oh, yes, we do.
Yes, no, or maybe. Maybe. No, right, we're waiting for people to...
Typical lawyer answer.
Yes. Okay. So, Cecelia, you want to answer this as if you're participating?
Am I participating? Cool. Yes, I will definitely chat. So the answer is most likely maybe, but kind of headed towards no. And there's a few reasons for this. So we can see whether or not the issue is whether or not there's an analysis that we need to do when we're looking at these types of issues. One is, does a ground of inadmissibility apply? And if it does apply, is there an exception? Or is there a waiver that's available? And so we can end the poll, Alicia. Thank you so much. And so we were looking at something about shoplifting. Shoplifting sometimes is an issue of intent, whether or not there is an intent to permanently deprive, but there is a petty offense exception. And the petty offense exception is kind of for minor crimes, but the sentence has to be for, was it less than a year? And so there's an exception that might exist based on the type of crime. But even if the exception did not apply, say there was kind of another criminal issue that was in place, the analysis that you have to go through, and I think that this is in your materials too, is, could we go to the next slide? Okay, no. So is whether or not it's going to cause any problems in terms of good moral character. And what are your thoughts on that? Do we think, how is this going to be an issue for good moral character? What do folks think? Right, because VAWA, we have to do kind of a we have to do a multiple analysis. It's not just inadmissibility issues that are in play. Because also part of the initial I-360 application is the issue of good moral character. And so, Maria, you're right. We're going to have to talk about it. But the question is, how do we look at this for purposes of good moral character? Does anyone have any ideas on how they would frame it or how they would address it?
Right. Viviana says it's part of the domestic violence. Right. So going back, Cecelia did that is it waivable question for you. And again, that's very complicated, and that's what we're here for, to help you figure that stuff out. And then once we decide, yes, it is quote unquote waivable, because you're not going to be asking them for a waiver at the good moral character stage, you are going to be doing this connection between the problematic acts and domestic violence. So as you say, it's part of the domestic violence, but just a little practice pointer, don't assume they're going to understand that. So again, this is where she's going to have to explain this in her declaration, and it's probably helpful to get a counselor or someone else who knows about the economic control to do a declaration to say, yeah, she had to do this because he was controlling all the money, and otherwise she wasn't going to be able to clothe her baby. Great.
Right, and I just put in the chat box the terminations of good moral character and VAWA petitions, and it talks exactly what Gail just mentioned, about whether or not there's a waiver available and whether or not you can show that there's a nexus to the abuse. And kind of that memo does a really good job of kind of setting up the framework of how you would address it.
Okay, so this is an extra credit question, and for those of you who are relatively new to this area, the main thing is to flag this as an issue to be aware of as you're interviewing clients. So Alia entered the U.S. first in 2011 because her son's father was abusive to her. She encountered immigration officials at the border, and they gave her a piece of paper. Ivan, as we know, is her LPR, lawful permanent resident abuser, learned she had a court date in immigration court, but he told her she didn't need to go because he would take care of it. So she didn't go. 2 years later, Ivan took the family to Mexico on vacation and left them there, telling them they could not get back in without his help. And I'm telling you, these are actual things we've seen happen fairly frequently, just so you know. This is not like off the wall. But Alia and her son came back in without permission because they couldn't get back in legally, and are now living here in the United States. What problems might this pose for getting a VAWA self-petition? Do any of you know? And are there any ways to fix them? Guadalupe is typing. So basically, the bottom line, while people are answering, is it's really important to find out how many times your clients have come and gone back into the United States and how they did it. So yes, Guadalupe says she is now subject to the ground of inadmissibility called 212A9C, which is based on having been here unlawfully in the United States for a certain period of time and then leaving and then trying to get back in without permission. But there is an exception, as Guadalupe says. She's typing, I hope, the exception. Yes, and because Ivan took her, you could, right. So what the exception says for VAWAs, and this is a big barrier for most people, but Congress did create, it's actually a waiver, that if you can show that any of the unlawful entries or exits or attempts to get back in are connected to abuse, then you can overcome this barrier. And as you're saying, Ivan took them back across the border and left them there stranded. In fact, the more typical thing we see is that Ivan will take the child that's a U.S. citizen child to another country, leave them there, and then the only way that the victim can get the child back is to go and get him or her and bring him back in. And that's often how they can trigger this kind of crap. Does anyone know, and this is like extra credit, what other issues this kind of scenario can cause? I guess the more obvious question, has anyone heard of reinstatement of removal? And very good, Maria, this could be a smuggling issue. It could be a trafficking question. But the issue I want to flag for you is it's really important for you all to know about this, because under immigration law, in this kind of situation where it looks like, oh, this is something that you'd have to be sure check out, that she was removed or ordered removed because of that court date she didn't show up at, and then she left and came back in, they could deport her without even a hearing in front of a judge or an interview. So that's called reinstatement of removal. There is a way, however, for approved VAWA self-petitioners to overcome that problem. But again, these are going to be the cases where your client has been removed or didn't show up at a court hearing and left and then came back in without permission. You want to flag those with us early on so we can help you set it up so down the line they can get their green card anyway. And many, many district offices of Citizenship and Immigration Services are allowing self-petitioners to get their green cards anyway, but it's because the folks who have done it have set it all up right and filed the right forms and made the right arguments. Okay, I think we're ready to move on to U visas. Oops, wait a minute. This is the old order. Old order is final orders of removal, which we used to call deportations. Basically the same thing. Those are really important to flag, but as I say, it doesn't mean they're not eligible and can't overcome them. And I think I just told you what you have to do before you can adjust. So, but when you have those cases, contact us and we'll help you figure out what you're going to do down the line and what you're going to do with a self-petition so you can avoid her getting picked up and deported. Okay, Ali and the U visa. I'm going to turn this over to you to run now, Cecelia.
All right, everyone. So now we're going to talk about OVIA in the U visa context. And if we can go back just for a second, I want to kind of provide some general updates on the U visa program before we kind of get into more of these details. And I think, I can cover up the slides, Gail. So, all right.
Okay, yeah, I mean, I think both of us can manipulate them, so yeah, I won't mess around with them while you're doing it.
All right. Because I have some very exciting news to share. And this doesn't happen often, but I figured since this is recent news and if you do U visa practice, that they have moved up the processing times at the Vermont Service Center to August 25th, 2014. So there's a jump about 2 months of the processing time. And again, these are the posted processing times that we have in order to take cases that are and put them on the U visa wait list. So this is not the processing time for the actual when the U visa is going to be issued, but this is just for kind of the initial placement on the wait list, that it jumped up over 2 months. It's been stagnated quite a bit, so I'm just glad to see that there is some kind of forward movement with this. And the other thing that I wanted to kind of flag in terms of just kind of the state of play for the U visa program, even is kind of considering that even though processing times have advanced, so there is nearly a three-year backlog in adjudication of these cases. And that if you look online, and I can post this as we go, there is a U visa data set and also a VAWA data set that are available on the USCIS website. For VAWA in particular, that they just started kind of issuing some data on the number of applications that have been received, approved, and denied, and they've been doing this every quarter for the VAWA, for the U and T visa program. And so I encourage you to kind of take a look at that because the backlog is significant. Currently there's over 97,000 pending principal applications and over 168,000 pending applications total, inclusive of both principals and derivatives, as of the second quarter of this fiscal year. And just to kind of point out to you for the fact that there's about 60 adjudicators both at the Nebraska Service Center and the Vermont Service Center who are working on these cases. So it is an extremely high volume of cases, which is part of the problem about why processing times are what they are. So I want to kind of just give you that as a general update before we kind of dig deep into some issues that might be together when you're putting together your case. Does anyone have any questions about that before we move on? All right, well, why don't we dive in? Okay, so our friend Aaliyah was at the house of a family member, and she saw one of her uncles physically assaulting her child. She got in the middle to stop it, and she got pushed to the ground. Let's assume that Aaliyah was helpful, called the police, and Aaliyah was helpful in the investigation and prosecution of this case. How would you potentially frame it? Can we put up the poll, Alicia? Alicia?
Sorry, I don't have this one as a poll.
Oh, okay, sorry. So how would we frame this case? I'm going to make it a poll. Would you portray Aaliyah as an indirect victim, as a bystander, or as a direct victim? Okay, so Maria says she's a direct victim. Maria, what would be the qualifying crime? How would you frame this? Again, this could be something that there might be different ways, so I'd be interested to kind of see. Oh, David says indirect. This is great. But I'd be interested in kind of seeing why you would think one is the other. Right. So Maria was also physically abused, right? And it says that she was physically abused potentially by a family member. And you have to kind of look in terms of maybe crimes of domestic violence would be inclusive of not only because it was one of her uncles, right, who had assaulted her. Because generally, kind of general simple assault by itself is not a qualifying crime. Felonious assault is, but also whether or not, because it was assault by a family member, how that's framed into your jurisdiction. So actually, it may or may not be a strong direct case, depending on how you would be inclusive of the definitions of domestic violence in your area. And so Alicia raises a very good point, right? So if there is physically assaulting or sexual assault of a U.S. citizen child, then that kind of puts us in indirect victim territory, right? And this happens oftentimes even if the child is documented or undocumented, or even a U.S. citizen. If the parent is involved in the investigation or prosecution of the crime, but is also suffering from harm. So I think that, or we can have a direct victim, which is a bystander, whereas you're kind of a witness to a case. And on the next slide, I think that I want to kind of look at this case and talk about the definitions and then talk about how the facts can potentially plug into them. So if we're looking at the different types of victims are those kind of three categories, right? And these you can find in the regulations at 8 CFR 214.14. When you're looking at a victim, means like a person who has suffered what they call the direct and proximate harm as a result of the commission of a qualifying crime. And so if you're a victim of sexual assault or domestic violence or stalking, that's easier because you themselves are the victim. When we're looking at indirect victims, and that is cases where if the direct victim is under 21, or where the direct victim was deceased due to murder or manslaughter, or is incompetent or incapacitated. So there's those three categories: deceased, incompetent, and incapacitated. And the issue that which we see is in cases of minors, whether or not one's status as a minor is in incapacity. And so therefore, you need someone else to provide the information in the crime. And so we've seen generally, USCIS and Gail, you can jump in if you've seen that generally for minors, parents have been able to apply for as an indirect victim of a crime, but they themselves have to meet all the requirements, including the substantial harm. So what you have is that you have someone who is a minor or under 21 years of age. Then the parents and unmarried siblings under 18 can also be considered to be indirect victims, proving that that established a substantial harm and the helpfulness in the investigation and of a qualifying crime, investigation or prosecution of a qualifying crime. And so for purposes of looking at indirect victims, you consider the age of the victim at the time the qualifying criminal activity occurred. And so if we're looking here, that there's a couple ways to frame it. If we can't have, if, for example, it was Ivan who was assaulting one of her kids and Ivan was the one pushing her to the ground, I think we have a stronger case of domestic violence. And so, but because it's an uncle, I think that depends a little bit more. But if we kind of see, depending on the gravity of physical assault, because child abuse in and of itself is not listed in the statute as a qualifying crime. But depending on what kind of assault, it could be potentially a qualifying crime. And then we have, we can frame Aaliyah as an indirect victim provided that she could prove her harm and that she was helpful in the investigation and prosecution of the case. And now I want to...
we do see a lot of these cases where the child victim was a citizen, and
right.
the mother who is not is the one who's applying as an indirect victim. So that's, I'd say that and the close family members of murder victims are the most used indirect victim examples.
Right, exactly. And I think that we see this a lot, particularly if you're looking at abuse of sexual conduct or any kind of sexual assault of a minor. We see it a lot in those cases where the parents will kind of be an indirect victim category. And I want to kind of just say a word on bystanders because, and if you're looking for a fun thing to do on your lunch break, I really invite you to read the preamble to the U-Visa regulations from 2007 because they provide a really interesting discussion on what bystander victims are. And because I really like you all, I'm going to put that link in the chat box because I know you can't wait to read it. But what the preamble to the reg says on bystanders is that they treat victims as bystanders who suffer what they say unusually direct injuries as a victim. And so they have in the regulations someone who suffers a miscarriage as a result of witnessing a murder. And I think that's kind of a pretty egregious example, but we have seen cases where people who have been present in the commissions of a murder or other crimes being considered as a bystander victim, or in the commission of other crimes as well that we have had people framing as victims. So, for example, if Aaliyah walked in and saw someone who was kidnapping her U.S. citizen child, and so when she witnessed the kidnapping, then there might be an argument to kind of say that she could be potentially framed as a bystander. But she has to kind of have that what's called a unusually direct injury. And so having that kind of be something that is pretty egregious in terms of the harm. It's not something that we see a lot. It's not something that we see, and I think it's actually, it's very, very uncommon to have these bystander cases.
I think a lot of people have misconstrued this as a third category beyond indirect and direct. It's really a version of direct.
Correct.
Direct victim is all about proximate harm. So those are the two. Before you start framing someone as a bystander, I would actually encourage you just to frame them as a direct victim. If you could, like what the example Cecelia gave, you can show proximate was that they were nearby and they actually witnessed it, and the harm was the trauma of being a witness. Usually it's the witnesses that fly of those kinds of cases. and the I think the struggle is getting law enforcement to certify them as a victim,
as a direct victim.
as a victim,
Mm-hmm.
yeah, rather than as a witness or the person who actually suffered, was the target of the crime. If they talk about the person who's the target of the crime, that's very confusing to Citizenship and Immigration Services.
And actually, the U Visa Law Enforcement Certification Guide that was put out by DHS has a pretty robust Q&A and talking a little bit about why would a parent of a U.S. citizen child need a U Visa certification. And so I think it does a really good job of thinking through some of these indirect victims issues. So I think if you don't know it as a resource, then I will post it here.
It's really useful.
It is really useful. Okay. So and I think this is something that we want to flag for you as something that we see similar in the VAWA vein of some of the, kind of the issues that we see for basic eligibility requirements in the U visa world is kind of showing harm. And I think that, they are used to kind of considering harm in the context of domestic violence and sexual assault cases. But sometimes they want more information or they don't necessarily understand that either sometimes they have RFEs where they don't necessarily kind of show a complete understanding of the dynamics of domestic violence and what might be considered to be harm. Has anyone gotten an RFE on harm for a U visa case?
An RFE is request for evidence.
Request for evidence, right. No?
Shocking if you haven't, frankly.
Right. Now, can I actually ask a question? Let me back up a question because I really like asking this question. The requests for evidence are put out in cases where Citizenship and Immigration Service just needs more information about one of the requirements of your case. Has anyone who has here received an RFE in one of their cases before? You can kind of raise your virtual hand, I think, if we have people who've received RFEs before. No one has received an RFE? You guys are amazing.
The kind of the flip side question is, have you won U visas without getting an RFE?
Yes, have you won a U visas without an RFE?
We never see those cases, yeah, but that may be because we just see the cases that have problems.
Well, I am just going to refer all my cases to you guys now because you guys seem to. All right. Great. So sometimes an issue is showing harm. So if you're thinking about harm issues, I encourage you to think about it in the same way as you would in the VAWA context and the types of documents that you would use to show extreme cruelty or battery or injury, and look at it through the same lens. And so in terms of accessing or their police reports or their are there hospital records? Are there pictures of injuries? Did they seek any kind of counseling or support services afterward? So I think, again, just like VAWA, the standard of what they're looking for in terms of the evidentiary standard is credible evidence. So the type of evidence that you would use to show in the VAWA context can also be used to show the harm in the U visa world as well. And oftentimes we see that many U visa applicants will require a waiver of inadmissibility. As part of the requirements for the U visa, it's not only is the victim of the qualifying crime, it is the substantial harm, it is the helpfulness requirement, it is the fact that the crime occurred in the United States or violated U.S. law, and the other one is that they are admissible or they can qualify for a waiver of inadmissibility under 212D14. And so the inadmissibility waivers is that it's very common that U visa applicants will need at least some, not always, will need, but that most commonly will need a waiver of inadmissibility. And so one of the grounds that are commonly included is entry without inspection. So if one person entered the United States undocumented, that would be something that would need to be considered in a waiver of admissibility. If there's also kind of common issues are smuggling when we're talking about bringing in citizens or bringing in children into the United States. There's like criminal grounds. And so I'm going to get the certifications, Alicia, I promise. But we're talking in other inadmissibility grounds. Has anyone had, in preparing a U visa, deal with any other grounds of admissibility? Something that Gail mentioned that you mentioned earlier, which is Guadalupe mentioned, was permanent bar issues, right? 212A9C issues, or if they have previously triggered unlawful presence. So it could be inadmissibility issues related to criminal violations, related to immigration violations. Is working without authorization a ground of inadmissibility? I'm not so certain of that.
Yeah. It depends on. I think we may. Yeah, and Cecelia, I think a lot of folks are only just now beginning to work on these and may not be lawyers. So I just want to back up a second and say I think on our website there's some good intakes that have questions that raise all the grounds of inadmissibility. Because just reading the law isn't really going to help you figure out what they are and how they apply to your client. So if you're not familiar with them, you should be able to find those on our website and some more background materials on what we're talking about.
Right, and also the U visa application itself does kind of flag some of these issues about inadmissibility. And so I think working with authorization kind of calls into questions about whether or not there's any kind of fraud issues or issues of other kind of fake identification things. And so I think that kind of working through those red flags, we can make sure that we get those to you towards it. But just generally, this is just to say that the inadmissibility waiver that's for the 192, again, is considered under what's called the national and public interest. And framing those cases, and we included a brief in your materials about kind of how we think that, especially in the U visa context, what national and public interest means. Because it's not really defined or fleshed out in the regs or any kind of other way. So if you take a look at that brief, I think that we need to kind of look at the U visa as the U visa program itself as serving a national and public interest. It was created by Congress with the dual purpose of providing protection to victims who come forward and also to be a tool for law enforcement in the investigation and prosecution of crimes and criminal activities. And so by virtue of people coming forward to report these crimes, to participate in criminal cases against perpetrators, it makes communities safer. And so looking at it from a public safety standpoint, and also looking at it from the perspective of how your client, how is not only that the visa should be granted for the benefit of the family or for benefit of their victim, for themselves as a victim, but also as the benefit of the community. So what are the community ties that your client has? Are they involved in their faith communities? Are they involved in any other kind of civic organization at their child's school? Are they in a neighborhood association? And so I think looking at those waivers in the context of not just the benefit to the victim, not just the benefit to the victim's family, but also for the benefit of the community in which that they are living in, both from the context of helping make their community safer and their contributions to the community members. And so here on certifications, and I think that Alicia...
So, Cecelia, yeah, can we move on? I don't think that, she's not talking about law enforcement certification. So I think we need to back up a little bit to talk about the roles of people who are on the call, because as I said, it's really hard for us to be able to tell what kind of job you do. But like with the VAWA self-petitioning, there's a lot that you can do if you're a counselor or someone who works with survivors of domestic or sexual violence to help put together the case. You obviously can't file the case and you can't answer legal questions if you aren't a lawyer or what's called a Board of Immigration Appeals recognized service provider. But the partnership model holds at least as true for U visas as it does for VAWA, because, for instance, as we move into certifications, many of you who are not the immigration lawyers are already going to have the relationships with local law enforcement that most immigration lawyers will not have until they start doing U visas. Um, and you're going to be in a better position to get the full story about, for instance, the how they suffered from the crime, as Cecelia was talking about. That's very similar to what we talked about in showing extreme cruelty. You're probably going to know the different ways that, for instance, a sexual assault survivor may subjectively respond to that crime that a lawyer we haven't been trained in that. That's not what we're trained on. So it sounds like some of you may not be able to actually file the applications, but we do encourage you to, and we can help you find the lawyers in your area who are doing these cases so you can build those partnerships. We discourage a kind of referral system because we think that's hard on the survivors. As Cecelia said, you don't want them having to tell a story 5 times. Plus, the reality is that, again, those of you who aren't the lawyers, you have a huge role to play in this. Not least among is doing the safety planning that a lot of lawyers, they don't even know what safety planning is, although hopefully the lawyers on this call do because you're getting OVW money. And helping them get the other things they need to get because sometimes, dealing with concerns about the children or whatever, especially benefits for citizen kids. I mean, something like that may be a higher priority for them than filing right away for immigration status. And having that kind of holistic approach is, we think, vital to helping immigrant survivors. So, Alicia, and any of you who aren't lawyers who want to chat with us more about what your role can be, contact us afterwards because that's certainly, again, we can connect you to the local lawyers, and we're happy to kind of work with you and the lawyers on how you can work together to move forward these cases. So I stopped there because, Cecelia, I thought that certifications is the obvious place, right? Where getting certifications from law enforcement is the obvious place where they can do it. Just one other thing before we move on to that. We actually participate with the Catholic Legal Immigration Network in an OVW-funded series of trainings for those of you who are not lawyers to become what's called Board of Immigration Appeals recognized and accredited. And I think the prime example we use is that the Wyoming Coalition Against Domestic Violence is now a recognized agency, and some of their non-lawyer staff are accredited to provide the immigration services. So you do have to get trained, but that's the idea, is that this initial training that we do with Catholic Legal Immigration Network gives you the steps on what you need to do next in order to be able to do those kinds of cases. Because the reality is, as you, I'm sure, know, that there just aren't enough lawyers who are willing to do these cases for free, which is most survivors can't afford to pay a lawyer to do these cases. So we really encourage you to think about building your own agencies, resources and skills as well as your own. Okay, turning it back to you, Cecelia, after my little rant on that.
No, that's
Okay,
helpful.
so
Thank you so much, Gail. I think it's important to kind of get a sense of, people's roles in putting this together because, if whether or not you're kind of screening for complex matters of inadmissibility just kind of might be very much outside what you are kind of have the capacity to do. And so, but getting certifications, if you're an advocate and you already have those established relationships with law enforcement officials, might be very much in your wheelhouse. Or helping a client prepare an affidavit or declaration might absolutely be very much in your wheelhouse. So I think regardless of your professional role, if there are different ways to plug into preparing and helping in these forms of relief. And I think in general also, like if you are a domestic violence or sexual assault survivor advocate, that there's a lot of capital that you have and the relationships that you have created with law enforcement, because the U visa and T visas, as I mentioned before, are law enforcement tools. And so your role is an exceptionally important one in putting those issues together. So I'm going to talk about certifications in the U visas context, which is a requirement for the U visa application and going forward, is a certification from law enforcement that essentially certifies two things. One, is that there was a qualifying criminal activity under the law. And the second is that the applicant was, is, or will be helpful in the investigation or prosecution of the crime. And again, so that certification doesn't talk about harm. That is kind of outside of the wheelhouse of what the certification is being presented to prove, is the qualifying criminal activity and the helpfulness requirement. And so some issues that we have with certifications is that the policies and practices in place are dependent upon the jurisdictions in which you live. So if you are in a jurisdiction where it is not, if they're not issuing U visa certifications, or if they're kind of putting additional requirements on U visa certifications, or if you're living in a jurisdiction with a good U visa certification policy. So some of the issues we just see is just discrepancies in how different law enforcement agencies are engaging with the certification process itself. And so, or there is some kind of confusion in terms of how, their role in the whole process, because I think oftentimes there's a misconception that the U visa certification is tantamount to issuing a visa. And so I think it's our role as advocates to clarify for that this is not, they're not kind of handing somebody a visa, that there are additional requirements that are going to be put forth to establish their eligibility, and that they are not the ultimate decision maker. The Citizenship and Immigration Services are the ultimate decision makers on whether or not a person gets a form of relief. And so I think that there's some tools in our tool shed. The certification guide. Has anyone used the certification guide before with law enforcement? You can put it in the check box. And that CIS is open to receiving questions from law enforcement agencies. If you think that your particular jurisdiction would benefit from asking someone who's a subject matter expert at Citizenship and Immigration Service, we can absolutely connect you. And there's also training opportunities that they provide specifically for law enforcement. So if you think that they'd be open to some kind of education or connections to answer their questions, we can definitely help out in that regard in connecting you to the right people. Does anyone have any other kind of certification issues they'd like to share, or anything on harm or inadmissibility or certifications before we move on? All right. So, again, the declaration for a U visa is a requirement under the regulations. And so, again, so we need those details, like we mentioned in the VAWA context. So not only, what happened, but also the impact of what happened on the victim. And again, this is why those of you who are advocates can be an extremely important part of this process, being able to kind of ask the questions in a way that is probably less likely to be as traumatizing as it is to kind of retell this story. And so, again, what we see from them is not necessarily understanding the domestic violence, sexual assault, and the trauma issues. And so we often have to kind of be educators that this is something like, for example, what we put forward into those guidelines that I just posted about. If you scroll up, the practice pointers on declarations, I think, are important, because you're talking about, if you are an advocate who's preparing a supporting letter, how your experience with domestic violence, your experience with sexual assault or trafficking, and then what this applicant's story and how that's credible based on your experience. And so framing up the support about harm is going to be just as important, like in the VAWA context as well. Some inadmissibility issues that we see coming forward out of them. So if you are an attorney, or if you are an accredited representative preparing a 192, it's very important to actually list all the different grounds of inadmissibility that you are waiving, including the statutory line. So if you're waiving a permanent bar issue, then we need 212A9C. So not just stopping at 212A9 and letting it kind of fall off. And this is important for a few reasons. This is important because especially if you have someone who's consular processing into the United States or someone who's entering, which is basically the process by which someone comes into the United States with U visa context, with a U visa, then that means that the people who are at the consulate, the people who are doing all of that work abroad, need to have a very clear idea of what was waived. Otherwise, it could delay or it could complicate that person's entry into the United States. The second way why this is important is that if it's not mentioned, then it's not waived. And so we used to have the practice that you would put in language like, I am sorry for these and all my inadmissibility issues of my past. And that catch-all language is something that we don't think that we've heard from in CIS is not helpful. So you should list kind of the grounds of admissibility that apply in your case. And then the other issue that we're seeing is on the issue of discretion. So you might have someone in a criminal history or in an immigration violation history that doesn't amount to particularly a ground of admissibility, but that the U visa itself is a discretionary benefit. And so they might deny something as a matter of discretion. And it gets complicated in those cases because if it's denied as a matter of discretion, there's no reviewability at the Administrative Appeals Office, which is where you would appeal, which is the body at the Immigration Service which kind of reviews applications. And so there's no appeal process for that. You can submit a motion to reconsider or a motion to reopen, but that there's no reviewability for abuse of discretion. And so that is kind of a complicated procedural point. But we're seeing more and more applications kind of denied as a matter of discretion. So it's just something to look out for, which is why I think tying back to that D14, national and public interest, is going to be very, very important. So if there are negative facts in the case that relate to somebody's criminal history or immigration violations or whatever it is that we're talking about, fraud, that we have to kind of balance the equities. So there's like, the scales of justice, weighing the good against the bad. And so what are all of those factors that can be considered in terms of establishing, weighing out the scales in your client's favor? And a lot of that we think has to do with the contributions to the community, what it took for your client to be involved in the process, and the investigation and the prosecution of the crime, and how that kind of led to and what that meant for them. The certification issues that we see that Vermont Service Center and Nebraska sometimes call law enforcement agencies to confirm, and that's just something to look out for. And sometimes we see something that's not obviously a qualifying criminal activity. This kind of happens, I think, outside the context of DVSA work, so I'm not going to spend a lot of time on it. But, for example, something that we see coming up is in the context of maybe robbery being defined as a felonious assault. And so there's no robbery box on the certification form. But so, and in fact, there's no other category on the U visa certification forms. And so they did that on purpose. They did that on purpose because they want you to put the criminal activity into the categories that they have established under the law. And another awesome reason, if you need another one to read the preamble to the regs, is because they talk about the criminal activities that are listed as categories. So it's not just talking about the specific, law under federal law, but they're talking about it in general categories of crimes. And so that's why I think it's really important is if you have something that is not particularly kind of able to kind of fit into not obviously in the category, then we can help you walk through how it might be possible to kind of put it in the category of a crime. How many people, you can kind of either raise your virtual hands or you can kind of just put in the chat box, how many people have had problems getting certification? I saw some
Looks
folks
like we
check.
have a
Okay.
couple. Yep. A few. Yep.
Okay. And if you are able to share, what have been the problems that you're facing? So Donalyn and Viviana, what kind of problems are you seeing in terms of getting those certifications? And again, while they're typing that out, because generally sometimes we see is that people are just giving flat out no refusals of engaging or issuing certification. Sometimes that the case remains open for years and they're not going to provide a certification until the conclusion of the case. This is something we see commonly, that they are only issued certifications at the conclusion of the case. And there's this wonderful webinar that Gail did for the Family Justice Center a few years back, and there is a prosecutor who used to be a prosecutor in Brooklyn, Wanda Lucibello, and who talks a little bit about kind of why she doesn't wait to the end for the prosecution, because she used to have that practice of by talking with advocates and realizing the need that some people have to begin this application process sooner rather than later. And so if you're receiving those kind of problems with your DA's office, then please do reach out for us, because maybe we can kind of have, as it says here, a better messenger. Because maybe it is not like Cecelia, the immigration lawyer, who's going to be the best face to this issue. But if you're able to speak to someone who you think who in your community is going to be someone whose message will resonate with these DA's office or will resonate with the sheriff's office. So it's thinking about who are the right people to have at the table if you're talking about these problems and talking about these limitations. And so exactly, so in Viviana's case, she said that it was denied because they didn't, even though the client had met with them several times, they didn't feel that they were cooperative. And so I think in those types of cases where you're running into the roadblocks, think about who would they want to hear from. Would your DA want to talk to another DA who maybe does the process a little bit differently? Would they have a better relationship if they reached out to maybe if someone in the city council was involved, or the mayor's office, or someone who you think is going to be a good messenger on these topics and engaging in these certification issues? And so, or maybe you can kind of think about if there's any other opportunity for joint trainings, or if you're on any task force together, and kind of ways to do that relationship building so that even if your client meets with them for 6 times, you can kind of say, like, all right, maybe that is cooperation in the investigation and prosecution of the case. And so I think kind of looking for those opportunities, looking for those pathways, looking for those right voices to be at the table is a way that you can kind of strategize about how to address these certification issues in your area. And if you have these individual cases, like Viviana and Donalyn, we're happy to kind of walk you through it.
Right, and do some troubleshooting and brainstorming, because this is one area where basically you don't have final control like you do with all the rest of an application you're filing. But,
Right.
you know, we've seen lots of different creative ways that people have tried to fix problems with getting certifications. CIS, Certificate Immigration Service, actually does webinars for law enforcement, and they have contacts at their agency who will talk directly to law enforcement. So, I mean, part of it is figuring out what is the real problem going on here, and is there a way to overcome it? So, for instance, when I train lawyers, this is when I often say that they should partner with a domestic violence or sexual assault advocate, because those of you who are such advocates generally have those relationships, and you can do what I call the negotiating between law enforcement and the client about, you know, why does your client not want to provide the help that law enforcement is saying it wants? Why does law enforcement need what it's saying it needs? Is there some place in the middle that both makes your client feel safe and gets law enforcement what it needs?
Right. And the other thing I'll say on that is, you know, it's reasonable requests from law enforcement, right? And so if you have someone who is like a minor victim of sexual assault who doesn't want to testify in person in front of their abuser, you know what I mean? Like, you have to think about the reasonableness of the request as well. And so that might be another area where you kind of look at, so, you know, that you're on the same page in terms of what is reasonable.
Right, right. And that's where when I do the trainings for law enforcement or for multidisciplinary groups, it's that this is why it's important to build those relationships before you have an actual case, you know, where you can run through these different scenarios and talk about, so what is a reasonable request, what, you know, given the context of the survivors we work with, that kind of thing. And
Right.
again, those coordinating community councils or whatever you call them where you are locally are really helpful forums for raising these issues and then suggesting further discussion and training.
Right. And what have you done in these cases? So Donalyn and Viviana, you mentioned that you've had some of these kind of obstacles in getting certs. What has worked for you in getting certification? Do you have best practices that you want to share with everybody? Or something that you think that you did that was really effective that you would want to share with folks? Oh, David, right, education and patience, we agree completely. So if you have, Donalyn, okay?
While they're doing that, I am have tracked down a few of our older YouTube recordings of basic immigration training, so I'm going to share those too. Okay.
Great. So we have some time remaining, and so right now I'm going to leave this open to kind of everything you wanted to know about VAWA and U visas but afraid to ask portion of our presentation. So if there's anything, questions you had on materials that we covered, anything that we didn't cover, I want to kind of open up the floor to you all in terms of if you have any case questions or want to talk through some scenarios, because sometimes these can get really complicated. And so it'd be great if we had an opportunity in the time that we have left to kind of strategize on some things that you might have actually on your plate. So Donalyn, you raise a really interesting point. And I think there's some kind of things to consider if you're going to have a declaration from the victim to reconsider. And does that mean a declaration that you prepared for the U visa application, or just a declaration? Because I think you want to be wary about giving the DA too much information, because there might be obligations, particularly if the case is ongoing, to provide information to the defense, because under Brady versus Maryland, which is the Supreme Court case, there might be evidence, disculpatory evidence that could be considered to be disculpatory, have that need to be handed over to the defense attorneys. So I think you want to be mindful of the communications that you have with the DA while the case is ongoing, and the materials that you give the DA while the case is ongoing, because you just want to be careful that you're not giving them things that might lead into the hands of defense. All right, so
It does say multiple attendees are typing.
right, so we're going to give
what,
you have 15 minutes, and we can kind of answer your questions as they come in. But while you're doing that, so here we have our email addresses, and so if you want TA from us, if you have case questions that you think of maybe after this webinar, then please do reach out for us to Technical Assistance. We're happy to answer your questions that relate to your cases and help you brainstorm some of these issues. If you haven't already created an account with us, we invite you to do so, and there's the link to do it, to register your organization with us so we can provide you the TA. And we will wait for your questions to come in.
So here's, you may have addressed this, sorry, Cecelia, I was trying to find trainings, but Donaldin says, is it okay to say how the perpetrator baby daddy has been absent and never visited her since they split due to DV? I think this is following up with the district attorney. Also, one point that to make is we have seen, if you can, the big thing is you've got to get a certification. Even a certification that says your client hasn't been helpful but does describe what your client does, we've seen those work, because then we can at least make the argument that what they're asking for isn't reasonable. Like, I think I don't think Vermont would think that the district attorney expecting the victim to find the perpetrator and present him is a reasonable request, to be honest. So, but if you can get a certification, that's yeah, right, you might still be able to get a U visa.
Right, or that same certification that says, oh, the client met with me 6 times and did these interviews, but they weren't helpful.
Right.
Well,
right.
Well, maybe CIS will see that a different way. So even if you get a bad certification, I think that you can kind of assess whether or not the facts are in there that, you know, you can use to argue that the opposite.
So it looks like Alicia has a different, yeah.
Right.
So Viviana wants to ask about VAWA petitions. They've seen them question the validity of these much more. Yeah, so Viviana, we're curious, the big areas, as we mentioned, that we're seeing them question is the good faith marriage. Are you seeing other issues that they're raising in the VAWA self-petitions? Oh, for men. Yeah. Okay, so for men, here's the thing I think we're dealing with is, again, I think this is where putting yourself in the shoes of the people who do all these cases is really helpful. They see, you know, thousands and thousands of cases where men are abusing women, right? And I think, frankly, they have seen some fraud schemes that are organized by some male groups. So I think and then your third problem is it's often very hard to document it because there are so far fewer services for men. So I think that's where you're up against with male self-petitioners, but we have seen them grant them. But I do think you're kind of up against kind of the mindset that men are usually the perpetrators, not the victims, and, you know, the difficulty of providing the corroborating documentation because it's hard to get services.
Right, and we can also connect you just to kind of some scholarship and some other issues that talk about male survivors of domestic violence, and so I think kind of educating them is also really important on this issue. If they're not getting it in their training, then I think it's up to us and incumbent upon us as advocates to do that education and make sure that they understand these issues in different contexts.
So Cecelia, here's a question right up your alley.
What is that?
This is a woman who was abused by an H-1 visa holder, which for those of you who don't know, they're often like professional visas, high-tech visas. Tell us about the work authorization for those folks. She suffered verbal abuse, but no physical abuse.
Are we talking about Donaldin's case?
Yeah.
Okay. Are the timing questions?
Well, let's just tell everyone first about the.
So let's talk about this. Okay. So I'm going to take your kind of case apart, Donaldin. So if she was, so in this case, there was an H-1 visa holder, which is an employment-based visa. And spouses are usually what is called under the H-4. And so VAWA 2005 created work authorization for abused spouses of A, E3, G, and H visa holders. So this application is called the I-675V, V like victory. And this is something that actually has been implemented just this year, even though it was put into law, 12 years ago. But now the process is forward, and so if we're just at the stage where she is an abused spouse of an H visa holder, she could get work authorization based on the abuses she suffered, and it's the same kind of credible evidence standard. And we'd be happy to kind of share information about the applications, about the memos that talk about the process and procedure. So if we were just at that stage, then she would be eligible for work authorization. Now let's add some facts onto your scenario. Now they were married and they lived together, and then she leaves because the husband has become a legal permanent resident. And if she was married, if they were married at the time that he was a legal permanent resident, so if there was a marriage to an LPR, then that could potentially transfer you into the VAWA world, right? And if they divorced after he became an LPR, then you would still maintain eligibility because divorce, you can apply up to 2 years after the divorce between the parties. And so I think that there's kind of multiple steps that you could look at here. And so we're happy to kind of walk through this case in a little bit more detail. But I think that there is a work authorization that you could get as an H4 derivative. But if there was a marriage to an LPR, then that would put you into VAWA world. But I think having more details of the facts would be really helpful.
Yeah, and this is, I have to say, I'm actually pulling up the statute because the VAWA self-petitioning statute, I always have to check which requirements are tied to which. Like, do you have to be married to an LPR when he was an LPR? That kind of thing. So
right. So the devil might be in the details in that case.
Or was it when the domestic violence had to occur when he was an LPR or when they were married? It's all, I always have to look at the statute to figure that out. So that's definitely contact us, as Cecelia said, to sort through those kinds of connections. And then, David, I answered your question about it's kind of similarly, which is contact us. David asked, short of getting a conviction vacated for prostitution, could a self-petitioner who was show good moral character? And again, that's going to depend a lot on the facts. And there's case law on like one time not being counting as a prostitution. And for those of you who aren't lawyers, this is going to be like, what's she talking about? But a lot of it has to do with the inadmissibility ground and, what you have to show for them to actually assert that you're inadmissible under that ground. So, again, the bottom line is don't assume someone isn't qualified. Always contact us, and we'll work it through with you and see if we can come up with a yes or at least some way around a no. So we have a few minutes left. Any other questions?
And if you look, and also I'll just point you to that memo that talks about what I put. If you scroll up in the chat, the good moral character memo, because it talks about prostitution as a grounds, as a bar to good moral character under 101F3, but that there are kind of, if you can show, for good moral purposes categories, if you could potentially show that there's the nexus. So I think we need to talk to you a little bit more, David, about the nexus between the prostitution and the abuse.
Right. And, it's something to think about, just another thing to throw out there, which we didn't cover, is that trafficking can be an individual trafficking situation, human trafficking. So if you're seeing someone being forced to have sex or to work against their will, even if it's just in the home, that might actually be a T visa case, and you can contact us to see if, and that's definitely worth pursuing if it is, because they are not getting, those numbers are not getting maxed out every year. Okay. So we'll wait for any further questions. Interesting. So Donaldin says they asked the police department to certify either for a T or a U, and they chose the U. I think a lot of times that's because the state trafficking laws are very recent and they're not used to doing those certifications. But as you
Right.
know, so, but you know, the useful thing is that for a T visa, you don't actually have to have a certification to apply for a
Right.
T visa. So,
Right.
so you might, what do you think, Cecelia? Maybe you could use the U certification to actually use that to apply for a T visa.
Yeah, I mean, I think you don't have to have the certification for a T visa. And so I think, showing that they, tried to make reasonable requests to comply with what law enforcement actually is. But if you got a U visa certification for trafficking, then I think that kind of puts you in a different category. So please do follow up with that.
Yeah, it would be interesting to see if you could basically use that as evidence for a T visa. And
That
not
would be
call it
interesting.
a
I have not heard of that, but I think it's worth exploring.
I mean, because they are telling us, right, Cecelia? CIS is telling us we should encourage all of you to apply for T visas. So it's like, well, let's try this. So.
Yeah, but I think it might confuse them if you give them a U cert for
Yeah.
T's. It'd be like, what are you doing? So I think thinking through the strategy would be useful. But it's creative.
It might be, maybe you could just supply all the information you gave law enforcement to get them.
Right.
Just without actually.
Well, if you already filed the U, then I think if you showed, I don't think you lose anything by also trying to file the T.
Mm-hmm.
And the processing times are much, much faster. And so I think that if there's a case to be made for a T visa, then I think that you should make it.
So the other place I like to flag for people to think about trafficking is if you see a survivor who's come in on a fiancé visa, I think there's a lot of individual human trafficking going on in the international marriage broker system. So you can always contact us to see if that's an option. That and VAWA might be options. Any final suggestions, Cecelia?
No, I just want to thank you everyone for their time and for being on with us today. And again, if this is the first one of the trainings that you're joining us for, then we encourage you to definitely reach out to us, and we're happy to be a resource for you and with you as you work on these cases.
And thanks to TA for sponsoring.
Yay! Thanks, Alicia. All right, have a good day, everyone.
Do we just sign off, or do you all Alicia, need to do it?
I will close out now. I was just waiting for the last person to type. Thank you all.
Thank you.
Thank
Bye-bye.
you. Bye-bye.